Breaking news! Breaking news!
All right, everyone, before I get started, just want to say thank you for tuning in, and you can always support the Cub Scouts Pack 997 to help kids discover scouting and learn some skills, outdoor wilderness skills, and other skills that might be useful and help them become men by donating down below. 100% of the proceeds goes to Pack 997, which is a pack of Cub Scouts. It's going to help pay their dues because scouting dues are outrageous right now. And it will also help pay for some of their activities. And if you are a sponsor out there that wants to sponsor a video or two, let me know. And 100% of whatever sponsorship dollars I bring in will also go to scouting, along with all my YouTube revenue for this month. So, and next month, and the month after that, and probably the month after that too. But just putting that out there. So we're going to be talking about a Second Amendment issue. When we think about Second Amendment issues, we usually think about gun rights, but it's not always gun rights. The term arm is not limited to guns. It's also incorporates other type of self-defense weaponry, including knives. And this case deals with switchblades, and it deals with the state of California in their ban on switchblades. A judge late last night, which I didn't want to do a video last night, so we're doing the live today. I don't want to record because I'm going to go on a hike later. Issued a motion for summary judgment for the state of California and denied the motion for summary judgment for the plaintiff, which included Knife Rights. Knife Rights is a knife rights organization. Think of them as GOA, but for knives. Really good group of guys there. I've talked with them and worked with them in the past, and they're a good group of guys, and they've been really, really successful on getting switchblade bans and other things overturned. But a district judge in California has ruled that switchblades are dangerous and unusual and therefore can be banned. The Knife Rights Organization sued using the Bruin decision, but it did not work. We're going to go over the ruling, then we're going to talk about it, and I might even open up the phone line, so we'll have to see, depending on how much time we have. So Rich is my reader. Rich is Flying Rich of the Flying Rich YouTube channel, and he's also the producer of my shows. So let's go for it.
Before the court are competing motions for summary judgment. Plaintiffs challenge the constitutionality of the California Penal Code. Defendants argue that the plaintiff's Second Amendment challenge fails under the current landscape of the Second Amendment jurisprudence. Having considered the parties' submissions, oral argument, and the governing law, the court denies the plaintiff's motion for summary judgment and grants the defendant's motion for summary judgment for the reasons stated below.
Basically, the jurisprudence they're talking about is Bruin.
Really? I've got a bunch of questions about that. So background, on March 15, 2023, plaintiffs commenced this action against the defendants in their official capacities as the state and city officials challenging the constitutionality of certain switchblades under California Penal Code. The challenged law makes it a misdemeanor to publicly possess, carry, sell, loan, or transfer a switchblade knife with a blade of 2 or more inches in length, which does not have a detent or similar safety mechanism. They also define the unlawful possession or carrying of any switchblade knife as a nuisance. Plaintiffs are individuals James Miller, Garrison Ham, Elliot Kagan, individual plaintiffs who desire to keep and bear regulated switchblade weapon retailers, North County Shooting Center and P whatever, and Knife Rights Inc., or institutional plaintiff, an organizational advocating for knives rights under the Second Amendment. The complaint facially challenges the laws at issue as infringing on the
Plaintiff's right to keep and bear arms in violation of the Second Amendment.
Oh.
Plaintiffs seek declaratory and injunctive relief to restrain the enforcement of the challenge law and any applicable attorney fees and costs. See, I can read.
Are we on March?
Yeah, I'll finish it. I'll finish it and go. On March 6, 2024, the parties cross-moved for summary judgment. Both parties respectively opposed on April 8, 2024. On April 15, 2024, the parties replied in support of the cross motion. The court heard oral arguments on the motions on May 8th, 2024.
So summary judgment. Summary judgment is appropriate where there is no genuine dispute as to any material fact that the movant is entitled to judgment as a matter of law. In reviewing the motion for summary judgment, the court views facts in light most favorable to the non-moving party and draws all justifiable inferences that the parties favor. Facts are material if it might affect the outcome of the case. A factual dispute is genuine if there is sufficient evidence that reasonable jury could find moving party, blah. Anyhow, when simultaneous cross motions for summary judgment on the same claim are before the court must consider an appropriate evidentiary material identified and submitted in both support of both motions and in opposition to both motions before ruling each of them, and cites legal precedent. Each party must carry its own burden under applicable legal standard, more legal precedent. Cross motions are no more than a claim each side alone is entitled to a summary judgment, and making of such inherently contradictory claims does not constitute an agreement that if one is rejected, the other is necessarily justified. Further, the court must consider each party's evidence regardless under which motion the evidence is offered, more legal precedent.
Yeah, they can deny both motions if they wanted to, but in this case they didn't.
Right, so it's not a Boolean, it's not one or the other.
Yeah.
Facial challenges. A facial challenge is a claim that the law or policy at issue is unconstitutional in all applications. Such challenges are considered the most difficult to mount successfully, citing case law, and are disfavored, more case law. To succeed on a facial challenge, a plaintiff must establish that a law is unconstitutional in all applications, more case law. Plaintiffs challenge California Penal Code as a violative of the Second Amendment. Specifically, plaintiffs contend that the regulated knives at issue are arms protected by the plain text of the Second Amendment, are in common use today for lawful purposes, and are not dangerous and unusual. In response, defendants argue that plaintiffs cannot meet their burden of demonstrating that the challenge statutes contravene the plain text of the Second Amendment. Defendants also argue that the regulated knives are not in common use for self-defense and are dangerous and unusual weapons. the court first briefly outlines the reshaped landscape for the Second Amendment jurisprudence before analyzing the constitutionality of the challenges.
Okay, let's go over this a little bit. There are a couple different cases that they're referencing here, but they don't actually say them. The first one is Bruin. Bruin says the first step of the Bruin test, which is known as the Bruin test, is to look at the original text of the Second Amendment and see if the original text allows for a law to be upheld as constitutional. Knife Rights claims that knives are arms, and the plain text of the Second Amendment says, the right to bear arms shall not be infringed. California denied that. They said that's not what the Second Amendment means. Then we go into the Heller decision. Heller says arms that are in common use cannot be banned, but dangerous and unusual arms can be banned. California Knife Rights is saying that switchblades are not dangerous, and they're not unusual, and they are in common use for self-defense. California says they're not in common use, and they're dangerous and unusual. So this is basically this is what step one. This is just going to the ruin. Step one is that but the people is interesting. The people is just read this. This is interesting. But step one,
First, the court should consider if the plaintiffs are part of the people protected by the Second Amendment. The Supreme Court made it clear that the people described in the Second Amendment are ordinary, law-abiding adult citizens, United States versus Ramos. Here, the complaint reads that the individual plaintiffs are natural persons who are U.S. citizens and seemingly law-abiding. Knife Rights is an advocacy organization suing on behalf of its members to defend and advance the right to keep and bear bladed arms. Retailer plaintiffs are weapon retailers who bring this action on behalf of its customers and would-be customers who wish to acquire these switchblade knives regulated in the challenge statutes. Together, all plaintiffs are members of Knife Rights.
All right. So basically, that it's going to go. It says that that nobody is claiming that the plaintiffs are not part of the people.
So, common use. The second, the court must determine whether the regulated switchblade at issue is commonly used today for self-defense. Through Heller announced and Bruin reiterated that the Second Amendment extends only to bearable arms presently in common use. Neither case clarified a metric by which the courts should determine whether a weapon is in common use. Instead, the latter case, Bruin simply repeated Heller's observation that the Second Amendment protects the possession and use of weapons that are in common use at the time. In contrast, dangerous and unusual weapons are outside the scope of the Second Amendment.
Okay. So I do want to, this is all legalese, but I do want to state that the stun guns, and there was a stun gun case where they found that 500,000 stun guns constituted in common use.
Here, plaintiffs argue broadly that defendants cannot prove the switchblade at issue are dangerous and unusual or uncommon simply because they are regulated, and defense experts fail to show genuine factual dispute over whether the regulated knives are dangerous and unusual. In arguing its second point about whether the regulated switchblade is dangerous and unusual, plaintiffs cite defense experts' reports on and disposition in starting that said knives are simply a variation of the folding pocket knife and possess no uniquely dangerous propensities. Okay. Plaintiffs claim that although defense expert Mr. Escobar names several characteristics that increase the danger of using switchblade for self-defense, his statements are contradicted by his deposition where he says each characteristic identified in his report are not unique to switchblades and apply to all folding knives or knives in general. Plaintiffs further argue that defense expert reports Mr. Spitzer, Mr. Rivas, and Mr. Escobar do not identify crime data from 1958 to 2004 relating to switchblades other than a 1950 magazine article. In plaintiff's view, because guns are more lethal and dangerous than regulated knives at issue, then such knives cannot be dangerous and unusual. Plaintiff's third point creates its own test for ascertaining commonality. In doing so, plaintiffs argue that the regulated switchblade is in common use today because they are common numerically, jurisdictionally, and categorically. Plaintiffs rely on pre-Bruin Fifth Circuit case, Hollis versus Lynch, to assert that the total number of a particular weapon shows that it is in common use. Using this metric, plaintiffs contend that 2 U.S. manufacturers produce over 1 million switchblades a year, and the total traffic in this country in switchblade knives exceeds 1.2 million a year, and that since the 1890s, switchblades have been mass produced. Based on sheer numbers, plaintiffs reason that switchblades, generally not exclusive switchblades regulated here, are in common use contemporarily. Plaintiffs also argue that regulated switchblades are categorically in common use because they claim that the knives at issue have no particular or constitutional distinction from a folding pocket knife, in that they have a blade and a handle and a grip, and that the blade rests within the handle or the grip when closed or collapsed, and when open or extended, it is fixed in a usable position. Plaintiffs argue that the regulated switchblades fall under the category of folding pocket knives, and it claims that folding pocket knives are possessed in millions of homes. Thus, plaintiffs contend that because automatically folding knives are categorically folding pocket knives, and folding pocket knives are legal in all 50 states, they are in common use. Across jurisdictions, plaintiffs argue that the regulated switchblades are not in common use, not regulated in 45 states, and
Are in common
36.
Regulated switchblades are in common use, not regulated in 40 states, and 36 states permit public carry, including Virginia.
And defendants counter argue, stating that plaintiffs make at least 2 analytical errors at Bruin. First stage, they claim that the arm does not have to be used for self-defense when an arm is possessed by thousands for lawful purposes. It is in common use and it is protected, full stop. And second, they assert that even arms not in common use cannot be banned so long as there are more dangerous than other arms in common use. Defendants contend that the correct inquiry is simply whether the weapons are in common use today for self-defense. Defendants argue that the plaintiff's preferred rule of determining commonality is based on sheer numbers, comes from Justice Alito's concurrence in Catano versus Massachusetts, which
That's a stun gun case.
which is not binding authority. Defendants also argue that plaintiffs never address whether the weapons at issue are in common use specifically for self-defense, and instead focus erroneously on common ownership and general sales, which has no bearing on the types of knives actually regulated by the challenge statutes and is insufficient to pass Bruin Step 1. Defendants further argue that the subset of regulated switchblades at issue are ill-suited for self-defense because it requires training in close hand-to-hand combat, and such inherently close combat results from significant physiological barriers. Defendants assert that Bruin Step 1 cannot be satisfied because general use provided by plaintiffs do not demonstrate that a subset of switchblades regulated are in common use for self-defense, defendants counter that plaintiff's jurisdictional argument by contending that California need only ensure that its laws pass constitutional muster, not that they align with the laws of other states. To support this argument, defendants invoke McDonald versus City of Chicago, stating that the Second Amendment does not eliminate a state's ability to devise solutions to social problems that suit its needs and values. Defendants argue that not only are regulated switchblades not in common use for self-defense, but they are dangerous and unusual weapons. Defendants point to 2 out of circuit pre-Bruin cases in arguing that federal courts have long recognized switchblades are uniquely dangerous weapons. Defendants also cite a collection of Ninth Circuit cases asserting that they show relationship between switchblades and criminal activity. The court finds that there are no triable cases as to whether the regulated switchblades are in common use today for self-defense. To start, plaintiffs identify no relevant authority in establishing numerical jurisdictional categorical commonality test apply. Beyond that, plaintiffs' created test does little to illustrate common use for self-defense. When briefly conducting common use analysis, Bruin stated that no parties dispute that handguns are weapons in common use for self-defense today. In line with Heller and Bruin, the court concludes that the inquiry as to whether a weapon is dangerous and unusual must be met to be tethered to self-defense, not lawful purposes generically, emphasizes in original indeed the number of switchblades allegedly sold in the country generally do not only the kind of specific regulated here does not prove that they are commonly used today for self-defense. Noted that sales statistics indicating millions of the regulated component were sold does not necessarily show that they are commonly possessed by law-abiding citizens. Likewise,
only millions of criminals buy $300 knives from companies like Microtech, I guess. I'll take it. Likewise, whether a switchblade is categorized as a folding pocket knife does not show common use of the regulated switchblades. At issue in this action is the regulation of a subset of switchblades that have a 2-inch or longer blade and no safety mechanism. As such, plaintiffs emphasizing that switchblades generally fall under the umbrella of folding knife does not address whether regulated switchblades are in common use. All right, go ahead.
In further applying its own created test, plaintiffs allege that 45 states do not regulate switchblades and 36 states permit public carry. Thus,
Virginia.
Switchblades are common use across jurisdictions. Bruin transformed the Second Amendment jurisprudence and abrogated cases that conflicted with its holding. McDonald is not one of those cases. McDonald is left undisturbed, and McDonald makes clear that while the Bill of Rights is fully binding on states, it limits but does not eliminate their ability to legislate solutions to social problems. Consequently, where other jurisdictions do not regulate switchblades is irrelevant, and it does not illuminate whether the regulated switchblades are in common use today for self-defense. Therefore,
there's no triable issue of genuine material facts as to whether the regulated weapon is commonly used for self-defense. With this conclusion, the court turns to whether the regulated switchblades are dangerous and unusual. Whether a weapon is dangerous and unusual is a two-part test, with dangerous and unusual each bearing independent meaning. Here, the court finds that there is no genuine dispute over whether the regulated switchblades, let alone switchblades in general, are dangerous weapons. In fact, the plaintiffs never argued to the contrary. Instead, the plaintiffs argue that the defense expert, Mr. Escobar, made statements in his report that switchblades have uniquely dangerous properties, which conflicts with his deposed statement. However, Mr. Escobar made no such conflicting statements. Rather, he says regulated switchblades have uniquely dangerous properties, namely they have an ease of automation. Though he acknowledged other knives may have similar design features, e.g., folding, he distinguishes them from the regulated switchblades because their ease of automation results in a higher propensity for failure than when a user tries to deploy a weapon, and the more moving parts a weapon has, the higher risk of failure, which is a bunch of bunk, but whatever.
While there is no genuine material dispute over whether regulated switchblades are dangerous for self-defense, the dangerous unusual inquiry tethered to the common use factor in Bruin Step 1 requires the court to also determine whether the weapon is unusual for self-defense. The unusual prong asks to whether a weapon is commonly possessed. If the weapon is dangerous and unusual, it falls outside of the Second Amendment's purview. Notably, neither party directly addresses whether the regulated switchblades are unusual for self-defense. Plaintiffs seemingly touch on whether the weapons are unusual by arguing that the weapons are widely used for lawful purposes. But plaintiffs never come close to arguing whether the weapons are specifically useful for self-defense. And interpreting Bruin Step 1 in alignment with Heller to require the challenged weapon to be in common use today for self-defense, defendants in a roundabout way appear to address whether that regulated switchblades are unusual by contending that they necessitate close hand-to-hand combat training to be used for self-defense, and such encounters create physiological barriers. Because plaintiffs bear the burden of satisfying Bruin Step 1 and fail to prove that regulated switchblades are in common use today for self-defense, or the weapons are not dangerous and unusual, it follows that there is no genuine dispute of the material fact as to this issue. Proposed course of conduct. Third, the court must consider whether the Second Amendment's plain text covers the proposed course of conduct. The Second Amendment reads, a well-regulated militia being necessary to a free state, the right of the people to keep and bear arms shall not be infringed. To determine whether the plain text covers an individual's conduct, courts must first identify and delineate the specific course of conduct at this issue.
Now I'm going to take over here. While conducting the Bruin Step 1 analysis, the plaintiff is not part of the people, or if the weapon at issue is not in common use for self-defense, then the proposed conduct cannot be covered by the Second Amendment. Analyzing the people in common use and then turning to whether the plain, okay, that's not exactly what Bruin said, but whatever. Then turning to whether the plain text of the Second Amendment protects Koch and Nash's proposed course of conduct, carrying a handgun publicly for self-defense. The Bruin court indicated that the threshold to determination to be made before comparing the conduct at issue in the amendment's language. Therefore, before analyzing whether the individual's conduct is protected, the court must determine whether the individual himself is protected, whether he is part of the people. Here, in their complaint, the plaintiffs state that the proposed course of conduct to keep and bear arms, the regulated switchblades for self-defense and other lawful purposes, the only other time the plaintiff directly named their proposed course of conduct is in their reply brief, which states plaintiff proposed action is to engage in normal, peaceable, commonplace, and constitutionally protected conduct with normal, commonplace, and constitutionally protected arms in Californians and retailer plaintiffs seek to offer these knives currently prohibited by California law to the public. Further, nowhere in this briefing do the defendants address plaintiff's proposed conduct, although neither party asserts fully fleshed out arguments under the proposed course of conduct. Factors of Bruin Step 1, the plaintiff's proposed conduct cannot be covered by the Second Amendment because the weapons at issue here are not in common use for self-defense and are dangerous and unusual. The weapon thus falls outside the scope of the Second Amendment, and therefore this factor yields no genuine material dispute. Given the plaintiffs failed to meet this burden of satisfying Step 1, the court need not proceed to Step 2. Even so, the court evaluates Step 2 below. So right there, they're saying that they've already lost, but we're just going to look at Step 2 just to do it.
Wow.
So go ahead.
When Bruin Step 2 is not satisfied, the court need not assess Bruin Step 2. See Bruin, blah. Nevertheless, Bruin Step 2 demands the government to justify its regulations consistent with the nation's historical tradition. To do this, the government must produce representative historical analogs that are relevantly similar to the challenged regulation in two important ways, and how and why the regulations burden law-abiding citizens' right to armed self-defense. Bruin suggests that 1791 to 1800 is the most relevant time period for identifying representative historical analogs, while classifying historical sources 75 years or later after the Second Amendment adoption as an outer limit. Defendants claim the regulation of weapons throughout the U.S. history tends to follow similar regulatory sequence. Certain weapons become associated with criminality or threats to the public. Order and safety are proliferating in society, and subsequently the government enacts a variety of restrictions on particular weapon while leaving a range of alternatives available to law-abiding citizens for self-defense. Specifically, defendants name Bowie knives and clubs as being historically analogous weapon to the regulated switchblades. Defendants state that Bowie knives.
Can you hold on for 1 second? The
Sure.
whole entire Bowie knife thing. We're gonna actually have Steven Stimbolia on next week to discuss Bowie knives and how that is being exploited by the courts.
Wow. Okay. Feature a long, thin blade. Defendants also describe Bowie knives as changing over time, be recognized as a large 8 to 12-inch knife with a clipped blade, one with a sharpened edge, swedged marking, making it more lethal, with the point generally aligned with the blade handle. Defendants reference various state statutes and specifically cite a Tennessee law that prohibit the sale of Bowie knives and argue that if these laws were challenged, they served judicial scrutiny because Bowie knives were linked to crime and were dangerous weapons. Defendants state that at least 3 states, Alabama, North Carolina, and Mississippi, impose high taxes on personal possession of Bowie knives as to prohibit them. However, defendants do not identify what qualities about Bowie knives make them representative analog to the regulated switchblade issue.
I don't think 1838 is a founding era either, but that's just me.
Defendants also identify clubs as representative historical analog. Defendants claim that laws regulating clubs date back to the founding era and that our nation's history has a robust tradition of regulating clubs. Defendants name 7 states regulated clubs spanning from 1664 to 1889.
Which
and
is
2 states that
which some of it is like outside the founding era, and the other part is before the founding era. And then they're going to talk about an 1805 law and a 1923 law, which is also not part of the founding era. So
both proposed historical analogs, defendants argued that their regulations are relevantly similar to weapons at issue in terms of how they were regulated because of their comparable burden and justification.
This is just saying that This is just saying that, hey, we found some laws. None of them were actually under during the founding era, but we found some laws. Wait, read supplemental.
So
This is it.
plaintiffs submit United States versus Duart as supplemental authority, but the three-judge panel's opinion, Duart, has been vacated and the case will be reheard en banc. United States versus Duart. Let's see. Both parties submit the United States versus Rahimi as supplemental authority, pointing to language that reiterates Bruin's articulation and application of the two-step framework, and to statements in their respective concurring opinions. As such, Rahimi provides no additional support to the court's Bruin analysis. Finally, plaintiffs also submit Worth v. Jacobson as supplemental authority. Worth is an out-of-circuit case involving state permit to carry statute that regulate public carry handgun rights of adults under 21. Worth, therefore, is not persuasive authority and provides no additional support here.
I think Worth
For
is
the reason,
if I'm not mistaken, and that was just denied en banc yesterday. So the next step for that's going to be at the Supreme Court. So let's then he just denies it.
wow.
So there's a lot, and I saw a good comment I wanted to address out there because I was going to bring it up, but someone else brought it up. So I am going to give the Sentinel some credit here. He says dangerous and unusual, not dangerous or unusual, and I agree. But it seems like the judge was using dangerous or unusual when she said that they're independent of each other. Well, and is a conjoining clause, so that means not independent of each other. So I'm not really sure if she failed English or what, but yeah. And then
I mean, English and logic, because
Second Amendment
dangerous.
Hold on, the Second Amendment is about self-defense from a tyrannical government. All right, keep on.
I'm always amazed at these additional clauses. The plain text of the Second Amendment makes no mention of what qualifies people, or that weapons are dangerous or unusual. It's of course a weapon is dangerous.
It has to be dangerous and unusual. If you say, if you separate it, then you could ban anything.
Right. If I was a carpenter and I have a hammer on my belt, I'm open carrying a hammer as a carpenter would do, and I defend myself with a hammer. Is that dangerous and unusual?
Exactly. If you want to call in and make a comment, you can at 844-CRUMPY0. That is 844-278-6790. Let's see if we have any calls.
The dangerous and unusual is another thing that's just crazy to me. I'm like, so one of their points are there are more dangerous weapons than a switchblade, so a switchblade is not dangerous.
No, I mean, it's to say, well, these other weapons are not banned, and they're more dangerous.
Yeah, I mean, there are more dangerous weapons out there, and so how could?
Yeah,
is there a scale of danger?
Yeah,
like if a shotgun is more dangerous than a switchblade, is a switchblade dangerous? If a shotgun is perfectly legal.
Yeah. This judge was looking for any excuse to cram to fine for California.
So this wasn't the worst anti-Second Amendment decision I've ever read. Kagan and Sotomayor have written some really bad dissenting opinions. Also Hawaii, what was it? It's in the Aloha spirit is the defense.
Yeah, the spirit of Aloha.
Yeah, so as far as a technical writing, this wasn't horrific. Of course, it's not pro Second Amendment, it's anti Second Amendment rights for knives, which I don't even know why
I said the judge he. I mean she, but I meant he. Sorry.
you didn't want to misgender or dead name someone.
Yeah, well, I
So
don't. Maybe he is. I don't know.
I don't even know what the knife statistics are. What makes a switchblade dangerous in my mind? It would it I would say that you would have to bear the burden of showing how many switchblade attacks end up in death to prove that it's dangerous, specifically dangerous.
Uh,
And again, I go back to any weapon is dangerous, and knives are not unusual. And again, I'm not for the dangerous and unusual characteristics or qualification. That's
yeah.
crazy.
Judge Simmons was appointed by Joe Biden, by the way, if you're wondering why elections are important, right?
I if
If
I have an
Trump won the
AR-9 that has like an ARC-1 that has like a dragon's head on the end, is that unusual, and does that make it specifically dangerous?
yeah. If Trump won the last election, this would have been heard by a Trump judge and not this guy, and we would have got a different. We would be doing a podcast today, but it would be like a show, but it would be a much different show.
Johnny Three Bar. A chainsaw is dangerous and unusual in the city.
Jason Voorhees,
Rocks are
or no,
dangerous.
Leatherface. Leatherface. I'm thinking of Leatherface. Voorhees used a machete, which is illegal in California.
Switchblades made in China and sold at gas stations for $24.99 are the most dangerous switchblades.
All right, we're gonna wrap up here unless we get a call. You can call in, but it's
Well,
something
while we're waiting for a call, don't forget
it's
to.
something I'm trying.
All right, I
Oh,
was
call thing.
just gonna pitch definition knives.
All right, you go ahead. Pitch definition knives.
So you can follow Definition Knives because we're going to be coming out with our product line probably mid-September. So follow Definition Knives on Instagram.
All right, I'll send you the PayPal so you can send me over the. Not just joking. Or the sponsor. Just joking. Yeah, I got another package going out to you soon, by the way.
Oh yeah, cool.
Yeah.
I keep a battery chainsaw next to my door. This way it's quiet.
Yeah.
Would that be considered a suppressed weapon? If you have an electric chainsaw?
It's probably according to the ATF, because the ATF will do anything to regulate anything that they can. All right, guys. Well, we're gonna get out of here. I'm gonna go for a hike here in a minute, in a few. But just wanted to remind you, if you want to help out the scouts, you can go to givesandgo.com/999. That's www.givesandgo.com/997, and you can donate to the scouts. And remember, the switchblade is so dangerous that if it wasn't for the switchblade, there wouldn't be those big West Side Story fights.
Yes, the Sharks versus the Jets. You got to watch out for that. You know how many times that goes bad.
Yeah, exactly. It's kind of funny. I was going to start out with a West Side Story joke, but I didn't. But I'm sure this is going to be appealed to the Ninth Circuit. We'll go to a 3-judge panel. This is a motion for summary judgment. So the district court is now done with it. This was on the merits of the case. So the next stop is going to be a 3-judge panel from the Ninth Circuit. there. It can go en banc or it can go directly to the Supreme Court. En banc is not guaranteed, and a writ of certiorari to the Supreme Court is not guaranteed either. We'll have to see what happens. I can't say if they're gonna win at the 3-judge panel at who's gonna win at the 3-judge panel on the Ninth Circuit. It just depends on the luck of the draw. 3 judges are chosen at random to hear the case. If you get 2 conservative and a liberal, or 2 liberals and a conservative, usually it's just not 3 conservatives or 3 liberals. That will tell us a lot more of what is likely to happen at the panel level, but we don't have that yet, and we will hopefully get that soon. Remember to be kind to your neighbors, spade your dogs, and Rich. No, just joking. Don't do that. But yeah, we're gonna get out of here. Did the ATF have a chainsaw handguard, aka barrel shroud? Is it there a switchblade in your pocket or just a little prick? This is an absurd ruling. The more judge pushing their morals and not the word of law. Exactly.
Amen.
Exactly. We got to have more constructionist judges on there, more constitutionalist judges on the bench. And the only way to get that is to have a Republican in office. Because, it's a binary choice, really. It's either Republican or Democrat. And I do not want to have Kamala Harris in office as president, or we're going to get more wackadoo judges on the bench, which would not be good for our rights. I'm not telling you who to vote for, but I'm telling you not to vote for Kamala Harris.
No Kamalama.
Yeah. And the Bowie knives, Steven Stambolia is going to be talking about that next week.
Okay.
Do we have any days? Wednesday, I got a back to school thing, but Monday, Tuesday, and Thursday, we have like we have 3 people. Do you have anybody scheduled?
No, I don't have any hard schedule yet.
I'll do that then.
Okie doke.
But yep. What do I think about RFK Jr., John? Huh? You could have called in and asked that, but I will ask and here. I think that he sees the danger of a Kamala Harris presidency, and that's why he endorsed Trump and dropped out in the swing states. So I think that is a good move on him because he's seen where the real danger is, and I salute him for putting his personal ego aside and doing what is best for the country.
There RFK, it's like a Venn diagram. RFK doesn't have tight alignment in beliefs with the Republican Party, but I think he believes in civil liberties. I think he's a lot of his beliefs align with libertarian beliefs, and again, there's right and left libertarians. But I think he's more of a liberty and freedom guy and recognizes the dangers of what the Democratic Party is doing. And I think it's a little crazy what they're doing.
Like Big Mike. Who's Big Mike? No, but yeah, I think it was one of his main issues is freedom of speech. And the Democratic Party, they're enemies of free speech right now. There's no other way to say it. They are enemies of free speech. I know.
Yeah,
I know the Sentinel. I was joking. I know the rumors about Big Mike.
Geico Camel Go.
Yeah.
So yeah, I find it interesting. The inclusive party did not include RFK.
Well, the inclusive party also didn't use their primary votes to determine who their presidential candidate's going to be there.
You mean the Democrat Party didn't democratically elect their candidate?
No, they didn't democratically elect a candidate. They tried to lock up their political enemies. They tried to remove the front runner in the presidential election, who's front running in electoral college votes from the party. They did successfully remove Cornel West from several different states,
Yeah.
and successfully removed RFK from New York and some other states. So. Yeah,
so it's going to be interesting, and we're
free speech.
I'm not sure how many weeks away we are from the sentencing of Trump in New York on the 34 felony charges. I'm a little worried about that, because that could be a lot of conflict. What's interesting to me is that case is about interference in an election, and the case is interfering in the election, or has a high potential to interfere with the election.
Imagine that. I think the case kind of backfired on him a little bit.
Oh yeah. It's kind of like whatever doesn't kill you makes you stronger, is what I've seen.
Well, look, I wasn't going to vote for Trump until they started prosecuting him. Then I said, you know what? F this.
Well, that's the same reason I own a 50 cal. I own a 50 cal because they don't want me to own a 50 cal. They want to lock up Trump and make him, put him in jail, pull him off the ballot. I'm like, whatever they don't want is what I want.
Yeah, whatever. All right. Hopefully one day the United States will have a strong lesbian leader. Damn. No idea who that is, but all right, that works.
Yeah, I think the only rational thing about the sentencing of Trump on the 34 felony charges is it should be postponed till after the election won, and there are many questions about immunity, which is the premise of that case. So the case is a little complex to understand and explain, but holy effing cow, to make all of the gymnastic leaps of logic to get to 34 convictions is pretty amazing.
It was the Ninth Circuit, Jeff, and that was the butterfly case. And when we have Stephen on next week, we can ask him about it, because that is him and there's a guy named Alan Beck in Hawaii whose case that belongs to. So we'll talk to Stephen about it, and maybe we'll have Alan on in a future date to talk about it. They're both good guys. But with that, I think we're going to be out of here. Thank you guys so much for watching. I hope you have a great weekend. And yeah, let's go Wolverines.